So, what qualifies as parental neglect in a California CPS case? Parental neglect is very vague, and it's usually sometimes conditioned based on what the department or the social worker feels is neglect. Because in order for neglect to be substantiated or actually legally stand, a conduct by a parent must have caused some sort of physical impairment or emotional harm to the child. If there was no physical harm, illness or anything like that, or emotional harm due to the parent's conduct, then how can there be neglect? And that is always the issue that needs to be argued. Now, oftentimes the social worker will see that a good example is drugs, marijuana. If a parent uses marijuana once a week or once every other week, it's not a chronic user, just use it occasionally, and someone decides to make a call for service as it relates to child abuse because of a disgruntled neighbor or friend or whatever, they investigate and they determine that the person is smoking marijuana due through the parent's statement. Sometimes the department will make a conclusion that there was neglect because the person smokes marijuana, and if it wasn't for marijuana, this person wouldn't be left. The child would not be left stranded or not given the proper attention or whatever the case may be. Unfortunately, that doesn't rise to the level of neglect, but social workers will oftentimes remove a child or keep the child in the parent's care, but typically remove the child from the parent's care because of that particular statement of marijuana use, and they'll classify it as abuse and say because of the abuse, the child is at physical risk of harm, illness, or emotional damage, even though there's no evidence that the child is emotionally harmed and or physically ill or damaged. A good example would be, they call it a drug baby case, where a parent uses drugs, but the baby test is negative, but they know that the baby should have tested positive, but didn't. Or the baby tested positive and there was no actual harm or illness towards that child. That's going to be like an iffy one because technically the fact that they tested positive is harm in itself, but there's no physical manifestation of injury. That could be a potential argument saying that the baby was not harmed or injured. That'd be a hard one. But the stronger one is that the baby did not test positive, despite the mom testing positive for marijuana, methamphetamine, or etc. If you or anyone you know is facing a child protective services case, particularly neglect, make sure you contact us at Shop the Law Firm so we can